Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
I do that every time. I'm terrible. I hope everybody's okay. Better than me. I'm fine. I'm just smoking a lot of weed. Anyways, I hope everybody's doing well tonight. It's a bit of a later one, and I'm using the other browser for some reason. So fingers crossed it works okay. It's slightly delayed compared to the other one, which is going to fuck me up, but that's okay. I would love to hear what you're having for dinner tonight or you had for dinner tonight. And if you didn't like what you had for dinner, tell me what you wish you had for dinner. Mark Westberg, what did you have for dinner? We would love to know. We've missed you. I am waffling on what to have for dinner. Waffles are not on the list. Salad is on the list. Oh, thank you so much, Vicky. You guys are so sweet. Oh, bacon cheeseburgers. That would be delightful. Not on the list though. Um, Watermelon and feta salad. Yeah. Yeah, I would eat that. If I had either ingredient, Mark, I'd be making that. I don't, but I'm gonna think about that now. That sounds delicious. Chop with a salad. Okay, okay, okay. This is a bit of a turquoise color. It's more like teal, I guess, but also it's got paisley patterns on it, some parts of it. So it's apropos. Apropos? Apropos. I want to give a warning about tonight's video because we are I don't know how to put this. It is not. Oh, you were yourself weren't a member? Congratulations. Oh, did I already do Vicky's? Look at me, like, first of all, thank you, Mark, for becoming a member. Secondly, did I already do Vicky's? I don't think I did. Did I? I'll do it again, just to be safe. Thank you guys so much for all your support, all your gifts, all your support, all your love. It means so much. So much. Okay. Now, oh, red onion. I love red onion. And balsamic too. There's a fruit fly around here. Why? She says. You had a great day. Oh, you got to say I told you so. But did you say as per my previous email, like in business speak, I'm gonna catch that. I hope everybody, like I said, is doing well. Hi, Colette. I'm scrolling through. Hi, Courtney. That's super weird. Unacceptable. But you know what? Time flies, Mark. So sometimes it's like, oh my God, was that a long? Oh yeah, you did gift yourself one. Julie's here. Not really late, Julie. We've barely started. Plus, I think we have quite a long one in the books for tonight, guys. I don't know yet, but we'll see how we do. Depends on how hungry I get. But I do have a drink, Canada Dry ginger ale, or ginger ale, as I would call it. Okay. So, what was I going to do, though? What am I going to do? What am I going to do? Oh, yeah. Warning about the TPO. So how do I put this? I don't like to diagnose people. I'm not a mental health professional. I'm not a lawyer. I mean, these are obvious things. Maybe they need to be said. However, when you watch enough court and you watch enough um, of these hearings, you get a vibe and you hear things over and over again. And then sometimes you hear things that you don't hear very often. So I know we do it all the time. What I'm saying is ahead of time, I'm concerned about this person and I wish that there was a different way that the judge could engage with them. But um this is going to be a TPO hearing. Hi Chris, thank you so much. Wait, let me play. Thank you. Do. Thank you, thank you, thank you. Love to see you too. Seriously, it's Monday, right? It's Monday. Yes, because we're doing TPOs. Okay, so I'm gonna pull this up on the screen. I might create frame while I do it. Hopefully it'll just be a perfect shot of my beautiful face. Oh, Svenya. She sings. Uh okay, so like I said, first red flag. Let's talk about that. This lady's coming to the court to get TPOs against two different people. Common denominator thoughts, you know what I'm saying? Anyways, let's continue. And I'm gonna dip off the screen so that it plays. It's like the train. I don't know. You know what I mean? I'm here.
Right. And Seth Alford, not in the courtroom, not on Zoom. That matter. And then we've got Ms. Harris and Daniel Dixon, not in the courtroom, not on Zoom. I don't know if you are, but Daniel Dixon's not here. I've already figured out you're here. All right, so. Give people enough time in case, and we've checked the other courtrooms. Nobody's in a wrong place, either by Zoom or in person. Check with other clerks in other courtrooms. Check. Yeah, they would just be in 2 or 3. Thanks. Good. Well, Miss Harris, why don't you come on up? Maybe we can get your matter going here, and then either one, whichever you like, whatever looks good to you. That red lighted thing doesn't amplify your voice, but we're recording and creating an audio record, and we're pretty good at picking up your voice. So don't worry, you don't have to lean into it.
Okay.
But just so you know what that is and why I have you up at the table. So, Mr. Benbow, you're there?
Yes, Your Honor, I'm in.
Okay. And can you start your video?
Sure.
All right. We've got Mr. Benbow, we have Ms. Harris. This is case number 24-233. This is a request by Ms. Harris for what, I'll let you, are you settled there, Mr. Benbow? Good
Just trying to
job.
have that light not so bright in the back there.
Thank you. That's helpful. I can see you then, not the light. All right. So Ms. Harris is asking the court to consider issuing an order against you, Mr. Benbow. I see that you were served on July 15th and just reviewing the things that I reviewed before. So you got the petition that was filed, which is all the information that Ms. Harris has told the court that caused us to set this hearing. And then obviously, you know, you're here. Looks like you got this declaration from this. Get it open so I remember. From Mr. Walden. Okay. So first off, Ms. Harris, this is the day to consider your request. We're going to hear from both sides if we do that, but I'm wondering, first off, are you still asking for this order against Mr. Benbow?
It was suggested because of the ongoing issues that I've been having with my phone, and now it's
You
my
want
work
this
phone.
order, though? It's up to you.
For my protection, yes, I do.
Okay,
I thought this
Mr.
would stop, but it
slow
hasn't
down.
stopped.
Slow down. I'm just trying to get where we are today. So, Mr. Benbow, there's not an order issued yet. We're going to consider that. Do you have an objection to the court issuing an order on Ms. Harris's behalf?
I more so have a issue with the
A
potential.
yes or no? It's a yes or no, and then we'll get into the guts of it.
Oh, yes.
Okay, now I know where we're headed. Sometimes you never know. So, and then Ms. Harris, you're ready to go today. You've got everything provided to the court and you're ready to testify.
Right.
Okay, so you're not going to be saying, whoops, I should have had another witness or some more information that I
I
didn't
tried to, but they're
file.
not available. They're on vacation.
Okay, so, but you're ready to go today.
Yes.
Okay. And then Mr. Benbow, you're ready to go today. You've got everything that you're wanting the court to consider. You're going to just tell me.
Well, I mean, this is all still brand fresh, new to me, this information. So I'm kind of showing up today to hear what this is about as well. I do have my son available to speak to because he was present for, when Miss Harris showed up at my, when she came by my house recently. And so,
Okay.
but besides that, I don't have anything else.
Okay. And so there wouldn't be anything else, even if we set this over another day for you. You're ready to go.
Potentially, I guess it would depends on, how serious this gets or whatnot. I mean, I may.
Let's talk about what this means. What this request is a restraining order, a protection order, a no contact order. It's all the same kind of terminology, but sometimes it's confusing to people that, it's just an order. It's a request by Ms. Harris and the provisions we would certainly talk about if we got into this hearing today and if it was ordered. But I would hear from Ms. Harris under oath. I would hear from you. And then I'd make a decision based on the anti-harassment laws under RSW 1014. Now, let's say this court does issue an order on behalf of Ms. Harris against you. A violation of that can cause you to be arrested and put in custody. It would be a criminal offense. That's how serious this is. And that's why I'm always wanting to be sure that people aren't just showing up to see what happens, because once we start this hearing, it's too late then to say, oh, hearing from the other side, I should have gotten this information to the judge. I should have gotten this witness to the judge. I want to be sure that everybody's ready to present their evidence today, because this is the day. It's not just to see what happens. And so you were served in enough time, and these things happen fast. And so there's a reason for that. We want to get to the matters quickly for people's needs, but that's why I always ask. And so I'm wondering, with all that, are you ready to go to this hearing today?
Well, when you mentioned about hearing from another witness, like I said, my son is here, but I don't know, is there any formalities I need to do in order to have him speak?
How old is he?
He's 20.
Okay. Well, all right. So and so you're ready to go today, or are you asking to continue this? I'm looking in your eyes and you look hesitant. That's why I'm asking that.
Well, because the severity, I have no issue with with maintaining this ongoing. I haven't had any contact with Ms. Harris for years, except for when she showed up.
Severity won't change.
I have no problem with maintaining the without contact. It's just some of the stuff outlined in here that could be a consequence against me if this is granted. I'm concerned for that. All the different allegations in here and stuff. I wouldn't want that attached to me. I don't mind.
So what does that tell me? Does that tell me you're ready to go today, or is there something else that you want to do? Are you asking for a continuance so that you can be prepared? I don't know what you're asking.
I hear you. I think so. If I could say at this point, I would probably be okay. But then somewhere, if it seems like this was, I may need to get a continuance.
If it's going sideways, if you're thinking it's going sideways, that would, we'd be in the midst of the hearing. It'd be too late for you to make a different decision about other evidence to present to the court. So now is the time to tell the court whether you think you're ready, or you want a continuance?
So, I'm thinking I may need to get counsel on this. Sounds like this may be something a little more serious. I don't really have any. Yeah, I would need to maybe talk with someone. I have been talking to counsel, but I only got this notice within a week ago. Like you said, on the 15th is when I got notice of this. And so I did. I've
Alright.
been speaking to someone, but I haven't been able to confirm it. They were out of town and whatnot, and so
Okay,
you know.
so there's a request, and I kind of expected that a lot. We do these things fast, as I said, and it's nobody's fault that he just got served a week ago. That was good. That was
Mhm.
actually pretty impressive that it got done so quickly.
Judge, actually, what's pretty impressive is Mark gifting 20 memberships. Oh my God, Mark. I love you. Thank you so much. You're amazing. Amazing. Ah! I'm amazed. Thank you so much. We do members only once a week around here. I know some channels do it more, some channels do it less. We do it once a week on Sundays. And you can go back if you just got a membership, welcome. You can go back and watch all the old members only. There's a lot of them. Anyway, so thank you, Mark, so much. Linda, you're later. Love it. You're not even that late. We barely started. It's gonna be a one. I'm eating popcorn. He should get a lawyer. Uh, okay, now I'm getting emails, but it's not about important. So let's continue. And we are going to hear, but the judge certainly was pushing this one away, wasn't she?
But it's a fair request from Mr. Benbow to set this over for him to consider your petition, to potentially just figure out how he's going to respond to it and consult with counsel, which is really difficult usually within a week's time to find counsel to talk to. So that's the request. And so Ms. Harris, it's a fair request, but anything from you about that continuance request?
No.
Okay, so we're gonna set another court date. Everyone, you don't have to serve anybody anymore. Everybody's gonna have that court date today, and then that gives you time, Mr. Benbow and Ms. Harris, if there's any other information that you wanted to give the court. It sounds like you were ready, but it also gives you time.
Okay.
So, looking to my clerk.
And the next date will be the 5th of August.
Are we setting today and this week to the 5th?
We are. This is a notice. So we can,
Yeah.
okay.
Yeah, all of them. Nothing. Once you have the hearing, the 2 weeks doesn't matter anymore. Yeah, so you don't have to limit it. All right. And this, how's the 5th look? Are we?
It's been pretty good tonight, Loud.
all
We
right.
barely had a creep frame.
Okay, so we're looking at, it's always on Monday mornings, and expect to spend your morning with us just in case. We're looking at the 5th, the 12th, Ms. Harris
Of August or
of August.
Am I able to do the 12th?
Pardon?
Am I able to do the 12th?
Yep, we can do it Monday, the 12th, Mr. Benbow, Monday, the 12th.
Monday the 12th is okay.
Okay, we got a deal. So that's it. That's the notice. We're gonna put in, do you usually put notice in the court file?
Yeah. it'll be-
Okay, so Mr. Benbow, you can access our court file with your Zoom instructions, if you're comfortable doing that. If not, contact the clerks. They can assist you there. You can come on in or however you want, but both of you can do that. And we're gonna put a court notice in there, but right now, August 12th, 9 o'clock in the morning, be back, you can appear by Zoom. Ms. Harris, we're gonna, if you'd like, hand you notice, a hard copy. Okay, we'll give you a hard copy. And then I suggest that before the 12th, so what I'd like to see is by the 5th of August, if there's any other information that you want to file with the court, get it in by the 5th, the week
Okay.
before, so that Monday before, so the court has time to look at it. And then the other side has a time to look at it. So both of you by the 5th, whatever you're gonna file with the court, get it in there.
But I have to have him serve what I'm filing, or do I just? get it
No,
into the
because
court?
each of you can get into the court file
Okay.
now.
Okay.
So, and then, each of you go look at the court file before the hearing on the 12th, so you're prepared for what the other side has presented, if there's
Okay.
anything.
Okay.
All right, so August 12th, 9 o'clock, and you can appear by Zoom or in person. It's up to either of you. So, Mr. Benbow, any question today?
I think that's it, Your Honor.
All right, so if you consult counsel, let them know about that date. And if you don't mind coming up here, Ms. Harris, and then that's it. You can be on your way, Mr. Benbow, but I need you for that other request you had, so don't go away.
Okay.
All right, we'll just have a seat. We'll take up your matter right away. Thanks, Mr. Ms. Harris.
Okay, have a great.
We'll just take your next case right away. That's okay. And you can keep your belongings. Thanks, Mr. Benbow.
Thank you.
Right, so it's now 9:22, and we're taking up your, Ms. Harris, you've asked for an order, court to consider issuing an order against Mr. Dixon, 24-234, Daniel Dixon Jr. I see he was served on the 18th. Let me I'm looking at this other screen because our files are electronic, so
Okay.
I am paying attention. Let me get to that file, 234.
If anybody would like to get their tinfoil hat now, would be a good time before we get right into this story here that we're about to hear.
Okay, so I do have proof of service, I remember now, from Tacoma Police from July 18th on Mr. Daniel Dixon Jr. And the court did not issue an order based on that petition to begin with, that set this hearing. And let me just re-review where we were on that one.
I'm eating candy. I thought about running today, so that sort of counts, but I didn't. Did I say aluminum foil hat?
All right, so let me put you under
Did I
oath.
say
If there's
tinfoil?
other information, so raise your right hand with me. Ms. Harris, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thanks. So I re-reviewed your petition, and I didn't see, was there anything else that you filed before today that I should consider? I didn't see anything.
No.
Okay. And it looks like there was an assault of you a couple of years ago.
Yes.
And then, but I can't figure out what you're saying recently happened that caused you to come to court. Which one of these? Because you didn't give me.
I'm being
any
harassed
dates.
via my email, my personal phone, and now it's my work phone.
So when did all this happen? Is the problem. I can't, was this recent?
I noticed that things have been happening for over probably last couple to a few months,
Okay.
but this may have been happening over the last couple of years. And I'm just now being aware of the extent of things that are going on.
Okay.
I traded in the vehicle that I had GPS on it and I was told to go to T-Mobile to have them attach my phone to something to see if I had any type of like spyware or something on there. They couldn't figure out what was going on, but they said as far as they knew, they couldn't find anything.
So why do you
But then I
say,
went to T-Mobile and I talked to the manager, and the manager he said, look, there's a couple of things that could be it. Could be a device that somebody, some way, somehow
That's
got
Mr. Walden?
probably both
declaration.
of them, because they've done it before.
Well,
is the thing.
okay, so the problem, all right, let me ask you.
Or it could be a
why,
computer that they attached to my
why
phone
do you
to.
say that this is Mr. Daniel Dixon Jr.? What do
I had a conversation with him
Yeah,
and I wanted to record something. And as I was talking to him, went to press something on my phone, and then he went and he pressed something to undo what I did on my phone. So there's some type of device or something that's linked.
so
when we
you're
had a
on the
conversation.
phone with him,
Right.
on your cell phone,
Right.
and When was this?
This was a couple of years ago.
Okay, so what about recently?
Recently, when I have my phone,
Mhm.
I literally have it where it's face recognition.
Mhm.
It tries to force me to not use my face. I have to put in a code. And I noticed when I put my code in, I could see somebody mirroring it on the background where they see my code, they put it in. I go to check my messages and I can't even get my messages. My text messages are supposed to be up. They don't come up. So somebody's receiving it on the back end. When I talked to your manager, said it could be a couple of things. Either there's a device that's attached to my phone, or somebody is able to do the VPN or the, I think it's called the IMEI. They are able to like mirror my
Die is unique to your device. And in fact, I think is it #6 that you can get it to come up on your phone. I think it's like #61 IMEI. It used to. Anyways, ma'am, again, when part of me, I realized like, oh, these are real precursors to people. Stop it. It's serious business. Let us have it. No, and it's StreamYard. And I submitted a ticket. And well, they said buy a new phone, but she says no, 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 no. And I'll let
phone.
Yeah.
Or it's, what was the other thing that he said? There was something else that he said. Oh, somebody may have that computer and they're able to like log in using my Apple information, which I don't know the backside of the internet, which is called the dark web, where they run your phone number and then like all your information.
Okay.
And I didn't even know a person could do stuff like that.
Yeah.
But it's weird because if I tried to go and like look at something, for example, like I was trying to shop and I was on I think it's called Safari on my phone. I'm scrolling up and then somebody's trying to like swipe. They want to see what I'm doing. My text messages, it's the same thing. They want to see who I'm talking to. I try to use my GPS. They showed me to turn off it's called Find Your iPhone.
Yep.
I had to turn that off because whoever it was trying to see where I'm going. And it makes no sense. And so finally I told my manager, I said, I have weird stuff going on my phone. Is there a way I can use my work phone? Because my work phone's an iPhone. And he said, there's certain things I cannot use it. Now my work phone, I showed him my work phone. He's like, if we have to get you another phone, he thinks that's weird, but to me, that's a little going overboard.
Well, all right. And so a couple years ago, you thought, or you knew, or how did you determine it was Mr. Dixon or Mr. Dixon?
I knew it was Mr. Dixon because like I said, we had a FaceTime conversation and I went to go try to record something to see if it would work. And when I hit record, he goes and I see him hitting something on his side that hit unrecord on my side.
All right. So you've seen this for the last 2 years?
He has some weird device. No, I thought that was the end of it. I didn't think anything else would happen. Had a conversation with him after that. And I was like, well, what's going on? I was like, are we beef? Or was we fighting or something? He was like, no.
Okay.
But then I said, certain things are going on. And he said the person that he had a conversation with was not available. He said that person, I guess, was like gone out of town or something. And I thought it would stop then because he said he would have the time. And so I was like, okay, well, he's going to have a conversation with whoever. I don't know if that person has anything to do with this. I'm not sure. Yeah. But I know he is the main one that started it all.
He knows about it.
Right. He knows about it.
When was that you talked to him?
I think that was a few months after that happened.
Okay. couple
And
years
then it
ago or-
happened again. It's almost like every few months. So that's when I'm like trying to think far back. Is this when it all started?
Yeah,
But it doesn't make sense. Like, we don't talk like that. We don't have sex. We don't do the things we used to do.
yeah.
Like, our friendship has changed. And it's similar thing with Mr. Bimbo.
Well, all right, so Mr. Dixon, then. I'm hearing what you're saying, but, and this is the problem, is the law may not have caught up with all this, but I have to find a certain.
Patronizing this, or understand how absurd this is. Like, if she's so tech unsavvy that she's like, well, fuck. Like, it's very concerning.
Standard to narrow in on him doing these things
I get it.
now. And so I'm asking all these questions.
No, I understand.
So when, all right. I believe everything you're saying, and I know sort of can happen, and I've heard it going through all this,
Well, I thought it
not
was
just you,
stopped,
but other
honestly.
cases.
Had I have did this probably a couple years back,
Mhm,
it probably would have been nipped in the butt.
mhm.
I thought everybody's moved on with their life. I moved on, they moved on. Apparently not. Because just I think this was a couple of months ago. And that's when Mr. Bimbo mentioned how I showed up.
Mhm.
I actually went to his job and had a conversation with him.
Mhm.
And I said, you know,
Mr.
what's going
Dixon or Mr. Bimbo?
with Mr. Dixon. I went
Okay.
to his job, had a conversation with him. But then I took his number out. I said, because it doesn't make sense for me to have his phone number and try to forgive if this is still going on.
Yeah.
I don't understand. If you're sorry about something, then be apologetic. Let's be fair about it, move on. But when it comes to a harassing of checking my emails, my phone to see where I'm at, that makes me feel he's worried about something.
Yeah.
Somebody is worried about something being brought up, and so therefore they want to know where I'm at. So it was suggested to me after I leave here to go get a license to carry and to go get a gun, just in case something happens.
Yeah.
Or to get a protection order. And I don't know what else to do other than this was what was suggested.
Yeah. Yeah, and that's the problem, is narrowing this in on one person.
I
and
get it.
having, and I don't know how to, and I don't know if
That's why I feel like
Verizon
I'm
or
stuck in a
T-Mobile,
loophole.
right, I'm hearing you, because how do you narrow this in on who's doing this?
Right,
Because if it could be narrowed in, then it would, I
It would
think,
be
match up
easier.
RCW
right.
and,
When
yeah,
I talked to
yeah.
the detective
Mhm.
who actually called me, I said, well, do you want my phone so that way you guys can like figure it out? And he said, well, let's do this first. He suggested I come do this.
Yeah. Well, and I think you're gonna probably meet with the detective again. I'm sorry, and that's the problem, the law is sort of behind and still requires me to find a legal standard that we can suppose, and I think, maybe, but it has to be a little higher than that.
I get it.
So I can't issue this order against Mr. Dixon.
That's fine. At least I
But
have something
there
on
may
file. That's
be-
what I was told.
Yeah, and there may be more that folks who are, well, you're talking to law enforcement, they're kind of getting real skookum on this kind of activity.
Mhm.
And if there's maybe T-Mobile or whoever you're working with, Verizon, T-Mobile,
Yes.
yeah, then maybe there's something they can do to help narrow in on who's doing this.
Password, and I've done that many times, and
Yeah,
whoever
yeah.
it is sees that I'm changing the password. So they know the passwords.
Yeah.
It's-
Yeah,
I've even gone to the point of, I want to change my phone number, but I feel like if they're using the dark web to see my name and the phone number attached, they're gonna get that regardless. So I'm trying to figure out how can I protect myself? What can I do?
yeah.
Because it seems like no matter what is suggested that I do,
Yeah.
they figure it out.
Yeah, I don't know what to tell you. I just know that this is where I'm stuck. So, all right. So what happens now on the Dixon matter is it ends today unless there's, more
Okay.
information to narrow in on who's doing this, and it really points to Mr. Dixon. Courts, would certainly consider that, and you're not prevented from refiling, referring back to this information and then whatever new that really focuses in, but it's going to take somebody who understands all of this to find a way to whoever's doing this.
Right.
Yeah.
Right.
So
Good
that's
point,
it on this
Victoria.
one, but we will be back on August 12th to talk about Mr. Benbow's, the petition against Mr. Benbow.
Okay.
And you got that notice.
Yes, I have that.
And so that's it for today.
All right. Thank
Sorry.
you. No, you're good. Thank you.
Okay.
So weird, right? That one was super weird. Okay. Now,
Oh, I see what you did. Okay, thanks. All right, so let's see. We don't have any, let me close this up and I can see my screen. Don't have any new folks showing up. So, let's see, the wards, if you'd come on up to the table there, and we can take up your matter. That's case 24.
They didn't get service. honestly, I watched the rest of it. It wasn't very interesting. So we're gonna go watch. That's weird. We're gonna watch a different docket, but wasn't that weird? I feel bad for that guy. I hope that he was watching. I doubt he was, but he should have been, because his lawyer will want to have seen that, right? That's my theory on that. Okay. No, watch your tone, ma'am. Ma'am, I'm not ready yet. I haven't even put it up on the screen. Jesus Christ. Oops.
DM Vanessa Hunt versus Matthew Hunt. Today is Monday, July 22nd, 2024 at 9:27 a.m.
Court will note of the appearance of Ms. McNiff on behalf of plaintiff, Mr. Toth on behalf of defendant. We have two matters before the court: the defendant's motion to modify parenting time and plaintiff's motion to modify custody parenting time support. Parenting time and plaintiff's motion to modify custody parenting time support and hold defendant in contempt for failing to provide health insurance. I do note Ms. McNiff, in reviewing the answer filed by Mr. Toth, they are agreeable to counseling in this matter, so that is a non-issue at this particular point. They have requested that parenting time in the summer be every 2 weeks rather than one, alternating to travel. Do you have an issue with that?
Your Honor, no, we think that's appropriate. I think the one issue we will have is with some of the makeup parenting time.
Okay. Well, the court will grant the request to modify the summer parenting time to have it in 2 week increments rather than alternating weeks. And anything else, I guess that takes care of a number of your issues on your note. Anything else?
Your Honor, Ms. McNiff has just made mention of the issue of what we'll call makeup summer parenting time, and that would apply to the summer, this summer, where we presently are right now. And there have been 2 weeks that Mr. Hunt has not been able to exercise parenting time, and I guess I will acknowledge that of the 3 children, the 2 older are presently refusing to go with their father for parenting time, which is the reason why it's mandatory that we get some counseling going on. But in regard to the youngest child, Lincoln, he's, I believe, 11 years old, and he looks forward to spending time with his father. But there have been 2 weeks that have been missed. The first, Your Honor, was associated with the where the 4th of July occurred, and the 4th of July was the holiday for the plaintiff, which occurred during my client's week. He's living in North Carolina. So in essence, because of that holiday, he would have been transporting the child 40 hours on the road during that 1 week, which everyone would agree isn't good for the child. In other words, it would have been picking him up on Sunday, returning him on Wednesday, picking him up again on Saturday or Friday, having him due back on Sunday, which is totally illogical and not in the child's interest. However, the parties were unable, or quite frankly, the plaintiff was unwilling to reschedule to allow the week to occur. So that would be week number 1. Week number 2, just a couple of weeks in Florida to Disney World with Lincoln, and I believe the other 2 children did not go. However,
These people have money and are petty. Who takes only 2 children to Disney World? How much do you hate your parents that you don't want to go to Disney World? I'm the lady and I want to go to Disney World or Universal.
Again, she didn't arrive back. I think it was until Monday at 10 or 11 p.m., whereas my client's parenting time was to start Sunday. He works in North Carolina. He can't wait for the plane to arrive Monday at 11 p.m., spend another night and then another day on the road. So why she would have scheduled that trip that way is we don't understand. And however, as a result of that scheduling and as a result of the distance between the parties, my client missed out on that parenting time. So we have 3 weeks left before the commencement of the school year, I believe, and my client is looking to begin parenting time. I think it's tomorrow, which will be from July 23rd at 6 p.m., having the child back here on August 15th at 8 p.m. That allows the child adequate time to get ready to go to school, gives my client a couple of weeks, and it alleviates the back and forth. I think everybody's already conceded that to go back and forth for 1 week it doesn't serve the child's best interest. So we would be looking there, and Your Honor, just again, as an aside, I think the relief requested by Ms. McNiff related to a change in custody, I think we're going to have a hearing schedule as it relates to that motion. Thank you.
Ms. McNiff, do you have any problem with, obviously he's only going to be able to make up the 1 week because of the schedule. You have any problem with that occurring?
We have a little bit of a problem with it. First of all, my client did offer to give up her 4th of July holiday so that the child wouldn't have to make that trip. So she offered that to Mr. Hunt. Mr. Hunt declined that offer. So from our perspective, he voluntarily gave up that week. I mean, there's absolutely no reason why he couldn't have taken his week, which was from June 30th until July.
Let's address the week that she had the child down in Florida and didn't get back in time, so he wouldn't be able to pick up the child properly. You have any issue with that week?
Well, the only thing is he's been available. He's been on vacation. He's according to my client, he's been posting on social media that he's not working. He's been out on his boat. He's been taking his stepdaughter to camp, and that he absolutely could have come up and picked up the child on the 16th rather than on the 15th. She offered to meet him so that it would make it easier. You know, she did try to accommodate that. We are willing for the child to go with dad from the 25th of this month through August 11th. The reason for August 11th is the child has a football meeting, the first football meeting on August 11th that he would like to attend. He has a meet the teacher night on August 14th, and then he has 5th grade orientation on August 16th. So while we understand that dad would like to have him for those times, these things are important for the child to attend. If dad takes the child from the 25th, then that makes up for 3 days of makeup time, which we're looking at as being that July 15th date. And there was also a date when she went to Las Vegas recently. Her plane was delayed and dad missed a day of parenting time there too. So that would be 3 days. Her week, his week would normally be from July 28th, I believe. And her week then would start would end on August 11th. So she's essentially would be giving him one of her additional weeks if they are on the alternating week schedule. So while that doesn't completely accomplish what he wants, at least that does give him some extra time and a big block of time.
Okay, what the court's gonna do is, the court does believe that her travel situation was an impediment, notwithstanding whatever he might have been doing. He couldn't change his schedule, et cetera, but she was the one that initiated the problem in this matter. So the court will grant the request that he have the child when the next parenting time would start, and then he would keep the child, I think what you said, through the August 15th date, Mr. Toth?
The request would be from July 23rd, Your Honor, which is, I think today's the 22nd, so that would be tomorrow at 6 p.m. on through August 15th at 8 p.m.
Court will grant the request for that modification. That'll take care of the parenting time issue. The arrest in this matter does appear that we would need to have an evidentiary hearing. The court does believe that the motion as well as the answer do meet the Vodbarka threshold for evidentiary hearing, so the court will grant that, and then we will be in contact with your offices to set that up.
Thank you, Your Honor.
You're free to go. Mr. Toth, you can prepare that order and submit under 7 days.
Thank you. I will do so, Your Honor.
Thank you. Have a good day.
Thanks.
Phew, we don't have to listen to them fight the whole day. Also, Vodvarka is a case where the requirement that a party seeking a
Good morning,
custody
Your Honor.
modification
Good
must
morning.
first establish proper cause or change of circumstances. That it became a seminal case because the Michigan Court of Appeals provided the clearest definition of proper cause or change of circumstances. The more you know.
Elisa, you need to unmute. Thank you.
Calling case 2024-1982 DM, Elisa Kleins versus Cole Kleins. Today is Monday, July 22nd, 2024 at 9:37 a.m.
Court will note the appearance of Ms. Henderson on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, exclusive use, and other relief. Ms. Henderson.
Good morning, Your Honor. Thank you. The parties in this case share 3 minor children. They're all very young, ages 5, 3, and 2. The parties separated on April 20th when defendant left the marital home. And since that time, he had 1 non-overnight visit with all 3 children. Plaintiff is contending that it is in the best interest of the minor children that she have temporary sole legal and sole physical custody of the minor children. And that is for the reason that relates primarily to the mental health of defendant. Lately, he has been having extreme anger outbursts. There's a current PPO in this matter, case number 2024-1284 PP, due to defendant's continued death and great bodily harm threats to plaintiff. Defendant caused significant damage to plaintiff's car recently, where she had to replace all the car seats due to glass being in all of them. He has damaged the marital home. He recently started excessively consuming alcohol. All of those issues signify that defendant may not be suitable to provide care and custody for the minor children in his current mental state. Defendant was recently arrested on a charge for resisting a police officer in the 4th degree, and he is awaiting sentence in that matter in the District Court of this county, case 2024 C246745 FT. It appears that defendant in his current mental state is not able to make sound decisions for himself. So it is reasonable to infer that he would not be able to make reasonable decisions for the minor children as well. Defendant works third shift Saturday through Monday every week, and his schedule is not flexible. Plaintiff works day shift. Her schedule is very flexible and can accommodate any needs that the children may have. It's also uncertain what kind of housing defendant currently has. It is believed he's living with his girlfriend, but we actually do not know the address of that, and that would need to be provided to the court for getting proper notifications. And we're not aware if he has proper car seats or beds for the minor children, and those would be necessary for the young children. For all of those reasons, we are seeking that plaintiff be granted sole legal, sole physical custody in the temporary period of time, with giving defendant non-overnight frequent parenting time that would accommodate the children's needs for supervision and care. We would also ask for defendant to undergo a psychological evaluation to determine if there's an underlying issue that causes those anger outbursts that could absolutely put the children in harm's way and cause defendant intentionally or unintentionally to harm the minor children.
Okay, thank you.
As it relates to child support, Your Honor, plaintiff is employed at Sunshine Toyota. She's salaried at $47,000 per year. Defendant works at Target Distribution Center. We believe his income to be $24 an hour, and he works third shift. So we're not aware if there's any differential for third shift. The children are insured through defendant's work. The cost of that is unknown, so we would ask that the parties exchange pay stubs for determination of proper child support. There is currently no daycare costs. Plaintiff has a lot of family members that are able to help with childcare if necessary. And we would ask for the child support to be established in accordance with the Michigan Child Support Formula. As it relates to the other relief, briefly, Your Honor, as stated, there are some anger outbursts that cause damage to the marital home. My client has been occupying that home since defendant left in April of 2024. She intends to keep that home after the divorce is final. She would assume bills associated with that marital home if she is granted exclusive use. She would ask that she be allowed to have exclusive use of the marital home. And given the circumstances surrounding this case with the PPO and other criminal charge pending, it is appropriate for the minor children to have a stable home in the marital home of the parties with plaintiff. As we stated earlier, we're asking for defendant to undergo independent psychological evaluation to determine if there are any issues that cause his anger outbursts and follow the recommendations of that psychological evaluations. We would ask for him to obtain proper car seats and beds prior to having any extended or overnight parenting time with the minor children, and provide the address to the court and to my client as well. Because there is a current PPO in place, if it's modified to allow child-related contact, we would ask that that contact occur through app close or a similar app for the parties' communication. So, Your Honor, we're seeking that my client be granted sole legal, sole physical custody of the minor children. Defendant be granted non-overnight parenting time.
Ms. Henderson, you don't need to reiterate. I've heard it 3 times already.
Okay, thank you. That's it.
Okay.
Thank you, Your Honor.
Mr. Kleins, what's your response?
Couple things. I didn't move out till May 23rd. And the only reason I moved out is because she had filed a PPO and was threatening to call the police on me. The broken window incident happened after I was assaulted by her and her mother. They said I only had 1 visit, 2 on 6/16 and 6/26, which I have text message proof of that. And then I also attempted to visit the kids on 6/2, 6/8, 7/3, 7/4, 7/6, and 7/18. My pay is $890 gross a week, and I pay $150 a week for insurance. And then I don't agree with the primary legal custody. I would like split legal custody, and she can have primary physical custody. and exclusive use of the home.
Okay,
Your Honor, there's one more issue that we brought in our motion. We're asking for the status quo to continue as to the car loan payment and the car insurance payment as well.
well, I'm not gonna address division of property or any of those things.
Just
at
during the
this time.
pendency of the divorce, Your Honor, so those
Again,
payments.
I
are
just
to-
said I'm not gonna address those at this time. Okay, what the court is gonna do is the court will, on a temporary basis, will grant, the plaintiff temporary custody. We can address the other issues as we proceed. Court will order support consistent with the support guidelines. Court would order that the parties would exchange income information within 10 days of today's date. That means providing check stubs or whatever you have, sir, to Ms. Henderson so that she has that and she can look through whatever it is. I understand you have the insurance, but she'll have to look through all of that. Court will grant plaintiff exclusive use because defendant does not dispute that she'll be responsible for the costs and expenses of the household. Court will order that, sir, what is your living arrangement such? Do you have bedrooms for the kids, beds, whatever it might be?
I do not at this point.
Okay. What the court will do is the court will grant you parenting time and alternating weekends on Saturday and Sunday from 9:00 a.m. to 5:00 p.m. each of those particular days. Yeah.
Real quick, I work Saturday, Sunday, Monday, 6 a.m.
Oh,
to 6 p.m.
That's right. I remember Miss Henderson mentioning that now. So it's Saturday, Sunday, Monday.
Yeah, yep, 6 p.m. to 6 a.m.
So you could exercise the parenting time from Wednesday, Thursday, Friday during those,
Yes, sir.
or for Thursday and Friday or some combination.
Yes,
Why don't
sir.
we do that? Why don't we make it on Thursday and Friday from 9 a.m. to 5 p.m.? Obviously, I assume the older child, he's 5, is going to be in school, so we may have to adjust that or something, but at least for now, he can exercise that and he can start this Thursday. The court would order that those exchanges occur. And sir, what's going to happen because of the PPO, the court will state that you will not be present during the exchanges. You'll have to have family member or somebody else that is familiar with the children that can in fact accomplish the exchanges. Obviously you need to have proper car seats to do that.
Real quick.
Yeah.
I know you said Thursday, Friday, but I know with her schedule and who watches them, if we could do Wednesday, Thursday, that would probably work better.
I don't have a problem. Is that all right, Miss Henderson, to do Wednesday, Thursday?
Lisa, can you confirm, please? You are on mute.
You're still muted, ma'am.
That would work perfectly.
Wednesday,
Okay.
Thursday works? Thank you.
Yes, please.
Okay, we'll do Wednesday, Thursday. In alternating weeks, we'll order that the defendant would not consume any alcohol or illegal drugs during the parenting time. The court would also order that all communication in this matter would occur through Miss Henderson's office. So, sir, if you have to communicate with, again, the plaintiff, you'll do that through Miss Henderson's office.
Including for like the visit times and stuff, we can't use the app Close app.
Do you have a problem, ma'am, with doing the app close?
No, that would work perfectly.
Your
Okay.
Honor, the only issue we have is I believe the PPO does not allow contact related to the children. So if the court would make that amendment, we have no problem.
Yep, court would do that, so the communication would occur through app close. I think that covers everything, and Ms. Henderson, you can prepare the order and submit under 7 day.
Yes, Your Honor, for the child exchanges, does the court wish for them to occur at the Battle Creek Police Station or any other place?
Well, if we have a third party, they can occur at the plaintiff's residence.
Okay,
Because it'll be a third party, not the defendant.
Is it okay if she drops them off at my parents' house?
Or your parents would have to pick up the kids, whatever the
Yeah.
case may be. because you have the responsibility for the transportation, notwithstanding the fact that you can't do it yourself.
Yep.
Okay. That will be the order. Ms. Henderson, you can prepare the order.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Thank you.
You too. Thank you.
Your Honor. Oh, he already disconnected. I wanted to get his address, but
Too late.
we'll hope he
On to the next.
contacts me.
Okay.
Thank you.
All right. so
What's next? We're watching this docket. He's jumping from case to case to case. Oh, Miss McNiff is back. Lost earlier, back up to the plate.
Client plans on appearing this morning.
She said that she was in the waiting room.
Erin Tinsman.
It's
name.
Lincoln.
Yes, that's her new name.
Thank you. 2022 2134 DM Aaron Gentry versus Peter Gentry. Today is Monday, July 22nd, 2024 at 9:50 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion to modify support with regard to child care expense. Ms. McNiff.
Your Honor, I would just note for the record that my client is recently remarried and her new last name is Tinsman. This is really a pretty simple motion. Right now, the parties are required to each pay 50% of any child care expenses. That was an agreement that they reached in their original judgment of divorce. Since that agreement was reached, my client is on has a different job. She's remarried. She has a baby. She had to leave her previous job, which still had her making significantly less money than Mr. Gentry, as a result of there not being sufficient PTO, sufficient sick time. She at one point was taking care of the children when they had COVID during Mr. Gentry's parenting time. The kids have had some significant medical issues, some like tube surgery, things like that she's had to take time off for, and she simply couldn't do it with the previous job. So she took a remote job so that she could meet those obligations. We've also been in court a lot, which was a difficulty for her and with her previous job. So we're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan child care formulation that would assign the parties percentages. We do have this matter currently in front of referee Snyder on a change of domicile request, change of custody, change of parenting time. However, this particular part of the child support formula was not at issue. And I think in order to get it there, the court needs to rule on it or send it to referee Snyder.
Okay, thank you. Ms. Thomas, any response?
I do, Your Honor. I don't think it's as simple as what Ms. McNiff purports it to be. Our answer to the plaintiff's motion certainly sets forth the defendant's position regarding the 50-50 childcare. However, I would add that to clarify, I just want to clarify a couple of things. First, at the time of filing our answer, this motion hearing was scheduled for last week. So we had said there was 9 days before we'd be in front of court again. We're actually in front of Mr. Snyder again on Wednesday of this week. And so there's no reason that this motion couldn't have been brought at that hearing. This is just an extra motion for no particular good reason other than it cost Mr. Gentry a lot of money. But more to the point, the parties negotiated. And they reached, it was by the judgment of divorce was entered by consent. And part of their negotiation was that because Mr. Gentry for a while was working at home, because that was part of what his job was doing, that's not the case anymore. And there was some variables, but the parties agreed that it should be 50-50. And that's what they agreed to that. And that's part of the other issues in the case settled because of that. So therefore, that was a negotiated agreement and it wasn't part of it. And if you look at the uniform child support order, although it's purported that it's in there, it's not in there. And if you look at the formula that's attached, the calculations attached, it's not on there. It does not say that at all because the parties had agreed that it was going to be 50-50. If it was summer, if it was before and after school, whatever it was going to be 50-50 because that was part of the settlement that they reached based upon all the totality of the circumstances of their particular case. for clarification, in plaintiff's motion regarding change of domicile, she specifically requested relief as it relates to childcare in this matter. And Mr. Snyder has in fact heard testimony as it relates to the issue of childcare. In plaintiff's motion regarding change of domicile, legal residence, although she indicates that she's also asked for custody and parenting time, in her motion, that's not true. In her motion, she acknowledged childcare expenses for the children under the age of 12 are to be paid 50-50 and specifically request a reimbursement regarding questionable childcare expenses. So this issue of childcare between these parties is already in front of Mr. Snyder, and he's already heard testimony. So to have another motion, another motion that we can again prepare for another motion, another thing is ridiculous. And also, frankly, one of the many reasons that Ms. Gentry used to persuade this court that she should be allowed to take the kids with her to her new boyfriend, now husband's home in West Virginia, was that she was offered a job less than 5 minutes away from her then boyfriend's home. And it was at a state farm agency, and it was contingent upon her being able to move there. And then she quit her job at State Farm here. And that was all as a furtherance of her career. That was one of the big things that the reason that she, was going to do this. And now she quit her job. She worked at another job. She worked full time. She said she was going to only work part time. There's been like, it was this and it's this and this. And it's like, and the testimony and the actions don't match. And she was going to have, and specifically, I believe that she said that plaintiff alleged in her motion that her fiance is, quote, supportive of a part-time work arrangement for her. His career is stable and he is well compensated, which will enable a more relaxed professional schedule for me. Yet she quit her regular job. She took a full-time independent contractor job, if you will, with no benefits. And then now and because of this financial affordability, because of her fiance's and now husband's income. And now here we are, we'd already agreed on this. This is something that they negotiated before Lisa was involved, before Ms. McNiff was involved, before I was involved. And now here we are saying, oh, well, wait a minute, that's not affordable now. I mean, I think she needs to use her new financial windfall and she needs to suck it up. That was their agreement. This is, again, 1/2 share of childcare expenses is what they agreed to. And it's not included in the Uniform Child Support Order. This issue with regard to who's going to pay what for last summer is before referee Snyder. So this issue was already in front of him. And this is, again, another motion that the plaintiff has brought that we have to prepare for, get ready for. And we're just asking that the court uphold the current order of the court, the judgment of divorce, which is the court order by consent of the parties. Although Ms. Gentry indicated that she has paid her 50% of childcare, she has not. She's not paid anything this summer at all. And now we have attorney fees in addition. And it's the same subject matter that's already before Mr. Snyder, that he's already taken testimony as to these issues, in fact.
Yeah, I don't have to have that read. I've heard that probably 3 times already, Ms. Thomas. What I'm going to do in this matter is, obviously, the judgment of divorce provides for 50-50 in childcare costs. It was by the consent of the parties. The court has not heard any reason why the court should invade and modify a judgment that was entered into by agreement of the parties, consideration of all the issues. The court is going to deny the motion. Ms. Thomas, you can prepare that order and submit under 7 days.
Your Honor, will the court consider our request for attorney fees?
I'm not going to at this time.
Okay, thank you.
Thank you.
Lisa loses again. Will she come back? Will she come back for a third round about with the judge? He ain't in a mood today. Sorry, he is in a mood today. Jesus. He's like, come on, Wordle. Come on,
He's on
Wordle.
mute.
Yes.
All right. Whitney, can you please unmute? Can you hear me?
Yes. Yes.
Case 2015-91 DP Whitney Gray versus William Johnson. Today is Monday, July 22nd, 2024 at 9:59 a.m.
Court will note the appearance of Mr. Umloff in this matter. On behalf of the defendant, this matter is before the court on the defendant's motion for supervised parenting time. Effectively, a court does note that there was an amended order for counseling and attorney fees back in September of 2022. Apparently, that counselor, Rebecca Walker, has recommended supervised parenting time with Frank Lewis of Kalamazoo Psychological and alternating weeks. Is that the substance of your motion, Mr. Umloff?
Yes, it is, Your Honor. We also request that the plaintiff participate in the reunification counseling sessions that Mr. Johnson is having with the minor child at the discretion of Rebecca Walker, the counselor.
Okay. Ms. Gray, what's your response?
My response is it really just depends on what time it's supposed to be at, because my work schedule is 8:30 a.m. to 5 p.m. and as it is, the reunification counseling sessions were already, like, she already changed her schedule around so that she could fit them in at a later time so my stepdad can get her there.
Okay, well, those are always difficult with the counselors and what they can work. Obviously, they attempt to accommodate those. All I could say in this matter for counseling, Ms. Gray, is if you're not available, you have to arrange to have somebody that is available to maybe transport the child for those particular counseling sessions. Because I have no idea what both of your schedules are or how that's going to coordinate or how it's going to coordinate with the counselor. So the court would order the continuation of the counseling with Ms. Walker, and also that there be supervised parenting time, a reunification counseling with Mr. Frank Lewis of Kalamazoo Psychology in alternating weeks at a time that the counselor can arrange that and attempt to accommodate the parties' schedules. Mr. Umloff, you can prepare an order and submit under 7-day, which would then reflect that.
Your Honor, what about the request that the plaintiff participate in my client's reunification counseling sessions with Rebecca Walker at Rebecca's discretion?
I said that the parties would participate in reunification counseling, so.
My apologies, I misheard you.
Yep.
Thank
Okay,
you, Your Honor.
Ms. Gray, you'll get an order probably within a week and a half. That will reflect. You're free to go. Have a good day.
Happy situation.
Versus Monarch and Forest and Attorney Redmond. Attorneys. Finance. Please unmute. Calling case 2024-1830 DM, Michelle Gregory versus Stephen Monarch. Today is Monday, July 22nd, 2024 at 10:03 a.m.
Court will note the appearance of Ms. Redmond on behalf of the plaintiff, Mr. Vanderhorst on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary support, custody, and parenting time. Ms. Redmond.
Good morning, Your Honor.
Good morning.
As a preliminary matter, there was originally a motion for genetic testing for this morning on the docket. However, all parties have stipulated and an order has been sent out for signatures and will be submitted and filed with the court later today.
Okay, go ahead.
And second, and Mr. Vanderhorst can speak to this as well, but we're currently scheduling mediation for this matter. And I believe we're tentatively scheduled for August 13th with Gale Town. And plaintiff today is requesting that the parties are awarded temporary joint physical and joint legal custody of Nevaeh, the minor child. Nevaeh was in plaintiff's sole care from about February of 2023 until August of 2023. And then defendant began exercising supervised parenting time. From November until April of this year, defendant exercised non-overnight parenting time. And then in April, there were 2 occasions in which defendant did not return Nevaeh to plaintiff at the agreed time. And since then, Nevaeh has been spending about 3 to 4 overnights per week with defendant from that time on. Plaintiff is requesting that they return to the stable schedule for the minor child. So the parties are awarded week on, week off parenting time for the duration of the summer vacation of Nevaeh, with exchanges happening on Friday, and then weekdays with plaintiff and weekends with defendant once school starts, to reflect the original schedule from before April, as well as any additional parenting time as the parties agree, and requesting child support as according to the formula. And that whichever parent is exercising parenting time is responsible for transportation. Thank you.
Okay, thank you. Mr. Vanderhorst, I think your answer has that reverse. It has your client having, or no, as your client having the child Friday or Monday through Friday, and plaintiff on Friday through Monday. Is that correct?
That's correct, Your Honors. The parties have about a 13-year marriage. They have a daughter who's going to be 13 in a couple of weeks, Nevaeh. She has lived primarily with my client since about April, 1st of April of this year. The parties separated last year. The plaintiff mother lives with the biological. She had a baby in April, a 2-year-old baby, or 2-month-old. She's going to be 3 months old in a couple of weeks. The current living conditions in the former marital home is the plaintiff mother, the father of the child. The child was just born as an infant. And then she has 2 older children as well. So it's a busy house, busy place. And plus the new infant as well. That is not my client's. My client lives with the daughter Nevaeh, who wants to, quite frankly, to remain with him in his home. She's been there since April. She finished out the school year there. And my client would like to keep that arrangement because it's working very well. He can get the child to and from school. He did last year. She's doing very well. She goes to Battle Creek Christian Academy. He pays for the tuition, which is $400 per month. He solely pays for that. The reason it's $400 is because there's an offset kind of a add to payments that were made before, so he's paying the full thing. I think otherwise it's typically $200 per month, but he's paying $400 a month to catch up. He does provide medical insurance for the minor child as well, and himself. And so what he would like to do, and what quite frankly the daughter would like to do, is continue this schedule going forward, where he would have Monday through Thursday or Friday morning. He does take the child to school. He does pick up the child after school. He's got a flexible schedule at work. And we believe the mother works at 5 in the morning till 5 in the afternoon. I don't know if she's still on maternity leave or what. We don't really know what's going on over there. But we like to maintain that schedule. That's what they've been doing for about 4 months now, Your Honor.
Okay.
I'd like to continue that.
Okay.
So that's really it in a nutshell.
Okay, thank you. Well, in this matter, what the court will do is the court will, again, the parties are not disputing that they have joint legal and joint physical custody. They're just really arguing about parenting time. The court would obviously allow the parenting time to occur in the summer in alternating weeks, from Friday at 6:00 p.m. to the following Friday at 6:00 p.m. In the summer, court would have alternating holidays as well. The court on a temporary basis would order that the defendant would have the parenting time Monday at 8:00 a.m. through Friday at 5:00 p.m. And then the defendant would have the child from Friday at 5:00 p.m. to Monday morning at 8:00 a.m. The court would have support set consistent with the support guidelines, and each of the parties would disclose their respective incomes through the attorneys within 10 days of today's date. So we can calculate that, and we'll ask Ms. Redmond, that you would prepare that order and submit under 7-day notice.
Yes, Your Honor. Thank you.
Thank you.
Your Honor, just for clarification, is that they're maintaining basically the schedule they're doing now?
Excuse me?
Is that what I heard? Would my client have the Monday through Friday?
Yes.
with the defendant?
Yes.
Okay,
Yep. 8:00 a.m. to 5:00 p.m. on Friday.
very good, Your Honor.
Okay.
1 second, Your Honor, that doesn't miss up next week's
What?
at all, does it?
No,
No,
because
okay.
next week is Monday through Friday.
Yeah, very good, Your Honor.
Okay, thank you.
Thank you.
Thank you.
She's freaking out down there.
All right, so next case.
Hi, Sue. Hold on. We have to go back. We have to go back and just listen. Watch the bottom square here. Listen carefully. She's pissed. She's pissed.
It doesn't care.
All right, so next case. Jennifer Lee.
Reed and Bartel.
She didn't win.
Jennifer, how did your client plan on appearing this morning?
He should be appearing over Zoom. If he's not there, I can give him a quick call.
Another one of our favorite attorneys. Not. Allegedly.
Please unmute. Your first and last name, please.
Ori Cronkite.
All right. Please unmute.
Hello.
Hello. Calling case 2019-2687 DC Ari Cronkite versus Taylor Morgan. Interested parties, intervening parties, Jamie Morgan, Carlina Morgan. Today is Monday, July 22nd, 2024 at 10:11 a.m.
Court will note the appearance of Ms. Reed on behalf of plaintiff and Mr. Bartel on behalf of the intervening parties. This is before the court on the intervener's motion for show cause for failure of the plaintiff to follow the grant parenting time order of June 12, 2024. In this particular matter, the court would note in this particular case that the court had entered that order. Ms. Reed had filed for reconsideration. Well, first she filed to stay the order. The court denied the stay. She filed seeking to again get reconsideration. The court denied that. She took the matter to the Court of Appeals, and we recently had an order from the Court of Appeals dated July 19, 2024, in which the Court of Appeals granted her motion for immediate consideration and then denied the stay.
What does that even mean, Mikey? Granted her request for an appeal, but then they denied the stay? Hi. What are you doing? We are plowing through what can only be described as a clusterfuck. Well, I hope you're well. It's bad internet is catching.
Result, that order that the court entered remains in full force and effect. It has not been changed, modified. The court will not do so until such time as we have an evidentiary hearing, which is scheduled for early August in this particular matter. Ms. Reed, what's your response to the motion?
My client is not withholding the child. The child is simply refusing to go, as we repeatedly stated. She's adamant that she does not want to see her grandparents. That's essentially what's going on, Your Honor. He's encouraging her to go. I've talked to my client. I've talked to my client about enforcing.
Who was that? That wasn't me. Who said liar? We're going back. We're going back.
Of this order. Not want to see her grandparents. That's essentially what's going on, Your Honor. He's encouraging her to go. I've talked to my client. I've talked to my client about enforcement of this order and the consequences. He understands. Our appellate counsel has also talked to my client. He's encouraging this child. She does not want to go and see her grandparents.
Okay, well, I understand, but child's 6 years old, and oftentimes court notes that children at that age don't want to do a lot of things. They don't want to eat their vegetables. They don't want to go to bed at night. They don't want to brush their teeth. All kinds of things they don't do. But as responsible parents, you have to do that. And the risks, sir, in this matter, let you know, is that you risk jail time if the child doesn't go for the parenting time. So it's up to you on what you want to do. If you want to do that, that's up to you. I can't again keep you from going to jail if you don't enforce if you don't comply with the order.
Your Honor, could I add just briefly for your information?
Sure.
I just want to respond to that allegation. They have not even made the grandchild even available. She has not even been at Mr. Cronkite's residence during the times that my client has tried to even pick up the minor child. The police have been present, and there's been times Mr. Cronkite has not even been there. So it runs shallow to suggest that they are trying to comply when they're not even available and making the child available for such grandparents.
Grandparenting time is so unique. Isn't that sad though? Can you imagine having to show up with the police for your grandparenting time and yet you get it? This guy right here is the grandparent's lawyer. What I guess is their custody dispute.
Parenting time.
Okay, I understand. The court will simply enforce its orders in this matter. So again, the plaintiff will have to have the child available for that grandparenting time, which means he obviously has to be there. The child has to be ready to go when they come to pick the child up. And that's what happens. And we'll address the contempt issues at the time of the evidentiary hearing in this particular matter. Only thing I would say, and Mr. I did receive the response from Ms. Reed and Mr. Bartel. You might want to have your client note that the intervener's trial by social media is probably not appropriate in this matter, and it would probably be well not to again continue to do that because it only had issues in this particular matter. So we'll.
Oh, somebody's been blabbing on Facebook. And the judge found out about it. I don't know.
Put it all over to that hearing, but the court will enforce its orders. And if it takes, sir, you're going to jail to do that, I will let you know. In the last 2 months, I've had 2 parents that have went to jail such time as they until they make sure that the parenting time occurred. So I'm just cautioning you as to that. So we'll see you back in August and we'll address everything then. And hopefully, Mr. Bartel, your clients are able to get their parenting time until such time as we have that hearing. So,
is there any makeup, I guess, in the meantime?
Well, we've got to get parenting time started, and then we'll address the makeup.
Okay.
Okay, Mr. Bartel, you can prepare that order.
All right. Thank you.
Okay, thank you.
He has custody and he doesn't seem to be making the children available for one of the grandparents who successfully intervened. Judge, come on. I don't have all night. I'm still deciding what I'm going to have, but I think I might want mushrooms. Oh, it's the weed case. Oh, this is the weed case again. Won't pay. I wondered what happened here. The guy right over here who stands, he's very verbose. He will talk a lot. Let's hope the judge cut him. Maybe that's what he was prepping for all these other times. He's like, for it.
Morning.
Please unmute.
There we
Michael
go.
Beckford, are you here for the Polaris Reed case?
We are here to view. My name was submitted, and John Polderman and I are just watching the hearing.
Just what?
Just watching.
Watching the hearing.
Okay.
Calling King 2024-1304 CV Polaris Fund REIT versus Evolutions Holding LLC et al. Today is Monday, July 22nd, 2024 at 10:17 a.m.
Court will note the appearance of Ms. Zobazak on behalf of the plaintiff and Mr. Ryan on behalf of defendant. This matter is before the court on the objection by defendant to the order in this matter, as well as objection to the receiver. I have reviewed all of the pleadings in this matter, so I don't need to have a reiteration of that, Mr. Ryan. You can simply, you might want to respond to plaintiff's answers in this particular matter.
Well, sure. Apparently they agree with the removal of the $10 million amount. So that's a positive. As to it seems now we're down to the selection of the receiver. And, for the reasons stated, it appeared that Frank Simon had far more experience than Mr. Bullock did with regard to a cannabis operation. They try to make a statement that I didn't include a statement of disinterestedness, but I don't see where that's required in the court rule, first of all. And secondly, I wouldn't have obtained his CV if I didn't first get his, if he didn't do a conflicts check before I named him. That would be foolish of me to do. So those are my responses to what is raised there. So I think that, and let me ask the court another question. I assume we've got two events here today and that we're handling both here at 10 a.m. So there's an objection to the 7-day order, which is scheduled for 10 a.m., but there's also the appointment for the receiver at 1 or 1:30 today. Seems that we could just handle both here today.
Yeah, we'll handle both. That was an error. Yeah. Should have not been set for this afternoon.
That's great. Thanks. So that's it. I mean, it's there as stated. So anything more would just be rehashing what I wrote.
Okay. So Zobazak, obviously I've reviewed your answer as well. I do note that you had, at least as it related to the order, had made various corrections as to various things. From what I'm getting from Mr. Ryan, is that the order is maybe not an issue at this point. It's the receiver.
Absolutely. If everybody agrees that the revised order submitted with my responses is essentially the order, but for the question of the receiver, that's absolutely fine with us, and we appreciate the efficiency there. We did go out of our way to accommodate the request relative to the dollar figures outstanding. That was fair. There were a number of other things that we weren't really pleased with and put back in there. But again, if we're not rehashing it, that's fine. Focusing on the receiver situation itself, as we put forth, there was a better CV to be submitted for Mr. Bullock, which we put in. I think it's really not productive to quibble over whether Mr. Bullock or Mr. Simon is better qualified. They're both really accomplished professionals in their field. What I think is really important is that contractually we have the right to pick the receiver that we want. The court has stuck tried and true to the contract since the beginning of this matter and has ruled repeatedly that Polaris gets to exercise its contractual rights, and that includes picking the receiver of its choosing. I also think it's really important to note that Mr. Polderman has recently joined Mr. Bullock. I think the court's familiar with Mr. Polderman. He also is a very accomplished person in the cannabis space relative to receiverships. I've done some public speaking with him in that regard. And so for all those reasons, tie goes to Polaris, right? Assuming there was a tie at all. And that's pretty much as easy as it is.
Mrs. Ovechak, I've never heard that as far as tie goes to the receiver there. But
Your Honor, the contract says we get to choose. They've, you know, they're in default.
I understand. I just try to make a little light of it there for a moment.
I'm having as much fun as I can as well, Your Honor.
Okay. Mr. Ryan, any response to that?
No, Your Honor.
Okay. Well, I do note in the objections in this matter, I do note that that obviously the defendants contractually waive the objection to the receiver under the documents. That in this particular matter, Mr. Bullock had provided an updated CV showing his experience in the cannabis industry. Apparently, from what that is, it shows three matters in which he is involved in the licensed cannabis business. Also, 3 other cases in which he'd been involved in mediation and or as a discovery master. Court is well aware of Mr. Polderman. I've had him serve as a receiver in other business cases, and he's done an excellent job in each of those particular instances. And the court can't quibble with the fact that both Mr. Bullock and Mr. Simon may be again qualified in this particular matter, but the court does note that it's the plaintiff who has sought the receiver in this matter, and for the reasons set forth previously, the court has granted that. I do believe it's appropriate. The court will appoint Mr. Bullock as the receiver in this particular matter, and the court does note that the defendant does not raise any of the other objections to Mr. Bullock as delineated under MCR 2.622 parens B parens 5, and that is the basis for the court granting that particular motion. So the court will enter that particular order. Mr. Zobasak, do we have that order in the file?
Yes. So yes, Your Honor, Exhibit A to my responses is the order in the form that the court should use. And I want to make one specific thing clear. In your prior ruling, you said the receiver would continue the quiet title action.
Judge is ours. He's going to sign our judgment
Yes.
on July 26th for 1.2 million.
So what's it?
Okay.
This is
Mute Mr. Bedford.
Your Honor,
ahead.
if I could, continuing. Exhibit A to our responses is the order that the court should enter. The one nuance I want to make sure you understand is there was a little bit of lack of clarity as to whether the quiet title action, this other case that we talk about all the time, was subject to the stay or not. That Exhibit A gives the court 2 different page 3s indicated with a slip page. The first page 3 stays the quiet title action for just 30 days, which we think is advisable to give Mr. Bullock time to transition into the role. At that point, he has to pick up that case and conclude it, and that's also noted in the order in a different section. The second page 3 exempts the quiet title action from the stay altogether, and that's up to the court's discretion, but I just want to make clear that you can just pick the page you want when you sign it. And the reason I set it up that way is, again, we are very anxious to get Mr. Bullock in play here after the delay since the court ruled. And so just a matter of your convenience there, Your Honor. I hope that makes sense.
What?
I don't know.
Okay. Well, the court will review those orders and enter the appropriate one. And that will take care of the matter today. You're free to go. Have a good day.
Thank you, Your Honor.
Thanks.
Exhibit A is the one for the receiver. Yeah. So I need to pull that. The other one, there apparently will be 2 of them in there. And the only difference is as it relates to the quiet title action.
Okay. This is the one with the interpreter, so let's.
Oh, fucking interpreter. That was a I'm just gonna mute that for a minute and while I talk to you guys here. That was a case about a marijuana company that borrowed money from a finance company, signed a contract, defaulted on that contract, and the finance company was exercising their contract rights to appoint a receiver, which is somebody who's in charge of the financial transactions of the company in the meantime to ensure that they don't liquidate assets, etc., or squander away money. And the receivership, the finance company's winning at this point, but he's just been following the contract.
Know if we have someone else or not have someone else.
Okay.
All right, we are going on the record. Let's see. Can you please speak? Hello?
Hello?
Interpreter, do you want me to start interpreting?
Just a minute, we'll have you sworn in first, ma'am.
Let me just check to see. Motorola, your first and last name, please? Hello?
Richard?
Yes.
My first name is Janet and last name is Parr, P-A-R.
Okay, is this the other party?
Are you David Pang?
David Pang.
Is that?
Let's have her sworn in first.
Okay.
What's happening?
Interpreter, can you please raise your right hand?
Yes.
Do you solemnly swear or affirm that you will truly and accurately interpret these proceedings between the court, counsel, parties, and witnesses in the matter now pending to the best of your ability?
Yes, I do.
Okay, hold on, Judge. I don't think any of these. So this is not the party, correct, Attorney Moss?
My client's indicated that is not the defendant. Thank you.
I'm gonna place you in the waiting room. I just want to make sure that.
Did you have wrong person in interpreter case on your bingo card? Mark it off.
Do not believe these are the parties.
Unfortunately, we have this problem, Ms. Moss, is again, one of the directions that we have on the Zoom says, the first one in fact says, re-identify yourself so we know who you are. And unfortunately, nobody reads the instructions, so they don't do that.
Please unmute.
Please unmute.
We just say our name?
Your first and last name, please.
Joni Moore.
Okay.
Joni Moore.
Okay, Joni, I am going to. Joni McClura, is it formally Joni McClura?
No, former. It's Joni Moore now.
Okay, I'm going to place you in the waiting room.
Oh my God. We don't have them
Okay.
at Lizette.
Please unmute.
Actually, that's what I want to make for some merch one day, a bingo
Your
game.
first and last name, please.
Mark Walkowitz.
Mark,
Okay,
walk
Mark,
with.
I'm gonna place you in the waiting room. We are
Thank you.
still working on our 10 o'clock hearings, okay?
Thank you.
All right, Judge, I'm gonna call this case. We do not have defendant David Thang in the waiting room.
I did make bingo cards at one
Calling
point
case
that were online.
2024-1677 DM. Law Thang versus David Thang,
Okay,
interpreter.
do we need, Ms. Moss, do we need the interpreter for your client or not?
That's correct. We need the interpreter for my client.
Okay. Court will note the appearance of Ms. Moss on behalf of plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, and exclusive use. Interpreter?
Interpreter.
All right, can you please repeat that for me?
I've acknowledged Ms. Moss on behalf of the plaintiff, and this matter is before the court on the plaintiff's motion for temporary custody, parenting time support, and exclusive use.
Ato tu mak mu kong hepetain kan mit mos ni kan ahet ning in abun to chang lai I lolo te ngak sia do ken ning kong he ki ban tok le sil dang ahet mi pol kha ma.
That's not Vietnamese. I lived with Vietnamese girls for a while. It might be Cambodian, but that is not Vietnamese. It's just not like circular enough. I don't know how else to describe it, but I know the sound of Vietnamese and that's not it.
Kan bon I chai chang lai.
Court will note that it is now 10:31 a.m. The matter was set for 10 o'clock a.m.
Ato he na di pasha le mit sam thom le pakhat asitang E court kan chin mi kha pasha ate.
Defendant has not appeared, nor has the defendant filed a responsive pleading.
I khat le khat wa hin lang dong lang lao dai kan thong dong akan khat lao.
As a result, the court will grant the plaintiff's motion in this matter.
Tu asirwanga ni hin I arak pura mi plaintiff ni aher mi adu mi kha thate in court ni atok tan tiak lai.
Court will grant plaintiff temporary custody.
Court ni kan atu I plaintiff na kan ngap sia do ken lolo se khat tiak lai.
Court will order parenting time.
Soon court ni kan ngap sia do ken nak ding kong ngak kap hi lai long se in chat in to ding in abun to lai.
Court will grant support pursuant to court guidelines.
Court ni chat in chat support tong dong kha tok tan tiak lai.
Court will grant plaintiff exclusive use of the marital residence.
Court ni kan makaka nga chat in kho nak ding kan abun tok tan lai.
And she shall be responsible for the costs and expenses of maintaining that home.
You know, do ken nak ding tu kha nang ma tuan do si te lai.
The court will order that the defendant will have a third party provide transportation to facilitate any parenting time agreed to between the parties.
I kap ni in makaka ngap sia ton nak heti ban to ka ka khan chat in motor tun ka nak heti ban to kha third party lai ni ahet ning in an tok tan te lai.
And the court, to clarify my point on the exclusive use of Ms. Moss, I had a note further says here, plaintiffs will pay 1/2 of the mortgage payments on the property.
Atu I mismos ni abun chim ning kha kan ma ni kan nak lao le plaintiff ni kan in man kha nar cheo pakhat in a cheo kha ama tuan do si lai.
And the court will, on the 1/2 to be paid by defendant, the court will deduct that from his gross income for purposes of determining the net for support purposes.
Chun khat lai ni kan makaka in man tar cheo kha liam ding in a income in liam ding in a sibi te lai.
Ms. Moss, anything else?
That's it, Your Honor. Thank you.
Ms. Moss hahet ni danga mo a ti lao te.
Ms. Moss, you can prepare that order and submit under 7-day notice.
Ms. Moss ni kan he's no hahet mi ka bun to te lai.
I will. Thank you, Your Honor.
I'll get that out of the way. Okay.
All right. Thank you.
Okay,
Someone
thank
hang up
you.
on
And
the
Ms.
interpreter.
Moss, at a later hearing, we will address
Thanks, you disconnected. All right, thank you, interpreter.
My pleasure. Thank you for using our services and have a good day.
yeah, you have a good day too.
All right.
Well, that was a bit of a cluster, but it worked. That might have been like a Native American language. She did look sort of, I don't know. I just know I lived with Vietnamese people for a while, and it's very distinctive, the sounds. Oh, here we go. We got more. Here comes, he's back. Motorola's back. Just like my roommate who's bitching about me not having dinner made for him.
Please unmute. Motorola 1, your first and last name, please.
Monica Richards.
I'm sorry, what was that?
Monica Richards.
Monica Richards. Monica, are you here for a hearing with Judge Kirkham? Yes.
That's a woman.
Monica?
I feel so bad. I misgendered her.
And I will bring you in when we're ready to call your case, okay?
Okay, thank you.
Thank you. Please unmute, sir.
Unmute. Hello,
Hello. Your first and last name, please.
Anthony, Anthony, Tyrone, which is my middle name, McClora, MCCLORA.
Okay, Anthony, I'm gonna place you in the waiting room, okay?
Yes, ma'am.
Thank you. Kristen and Mark, can you both hear me?
Yes.
Kristen? Calling case 2016-882DS, Kristen Newby versus Mark Walkowitz. Today is Monday, July 22nd, 2024 at 10:37 a.m.
Court will note the appearance of Mr. Schaefer on behalf of the defendant. This matter is before the court on the plaintiff's objection to the proposed order. That would be the ex parte order entered on July 1, 2024, placing the children in the temporary care of the defendant pending the CPS investigation. Ms. Newby, you can proceed.
Please unmute.
You're muted still, ma'am. You got to hit the mic in the lower right, left corner of your screen.
It's go
Okay, can you hear
time.
me?
Yes.
Okay. I didn't hear the beginning of what you were saying. I couldn't get my my computer speaker to work.
Okay. All I did is acknowledge that this matter is before the court on your objection.
Yes, sir.
Go ahead.
I do object for him keeping my children for me during this matter. Our children need to be with both of us during this time. I wrote a letter here. I don't know if I need to read everything that is on here from my objection that is placed in front of you, but I do feel as if our children are being put through so much more emotional stress and being kept apart from myself and them. This is the longest we've been away from each other. I know without a doubt that this is not in the best interest of our children, let alone our daughters who need to be with their mom and have expressed this. Our children should not be being kept from me. I believe I'm falsely being portrayed as an unsafe parent to our children, and there is zero evidence that I am or ever have been an unsafe parent. I've agreed to and signed the safety plan that the CPS caseworker provided me, and the safety plan states that Audrey and Bailey have zero contact with Adam Lafferty and that we have no communication about Adam. I have yet to been able to follow this plan, Your Honor, or prove that I can follow this plan. I have my own apartment here. I have a full-time job. I'm doing everything I can to prove that I'm a stable parent for my children, and I feel like I'm being portrayed that I am not.
Okay, thank you. Mr. Schaefer, your response.
Well, the situation is kind of the same as it was at the ex parte order, that these twins had relayed some inappropriate touching to not only their father, but to their mother also. And she admits in her objection that she was told that the boyfriend was rubbing the belly below an area that was appropriate, that the boyfriend had touched the crease by her leg. that to me is inappropriate. And my understanding that the CPS investigation is still ongoing, and there's a criminal investigation ongoing, and it has not been completed. So I think the situation is still the same, and for the well-being of the children, I think the order ought to be continued. My client, I think, has been communicating with the mother of the children to keep her advised as to their activities and so forth. But at the moment, I think the order ought to be continued.
Okay. Well, the court does note that these were very serious allegations made by the girls, and the main concern of the court is the protection of the children. And there was sufficient information that while in plaintiff's care, they were at risk of physical, mental, or emotional danger. And court notes that CPS and as well as police have a criminal investigation in this particular matter. What I will do is state that there may be some provision or whatever. Ms. Newby, if you contact Mr. Schaefer, maybe you could make some arrangements where you'd be able to have contact with the children outside of the home or something of that nature, some sort of a limited parenting time. So I will leave that up to you. If not, you can always file a motion for parenting time, but I don't believe that it's appropriate to, again, vacate that order at this time. So the court will continue the order and deny your objection at this time with the recommendation that you contact Mr. Schaefer and try to arrange some sort of time where you can have contact with the children. Okay, that will be all we'll do today. And Mr. Schaefer, you can do an order denying the objection.
I will, Ms. Newby, give my office a call. We'll see what we can work out.
Okay, am I not allowed to say anything further?
No, okay, the hearing's done now at this point.
Okay,
Thank you.
thank you.
Next case is McClura versus McClura. And we have both parties present.
But he gives 3 days to fucking bathtub people at the bathtub.
Joni?
Yes, I'm here.
Calling case 2013-3089 DM Joni McClura versus Anthony McClura. Today is Monday, July 22nd, 2024 at 10:43 a.m.
Parties are both appearing in this matter in pro per. The defendant has filed a motion in regard to support. He states in the motion that support should be modified as the parties do have an equal parenting time agreement. I'll ask Ms. Moore, is that correct?
Yes, I let the child go with him when she asked.
That's not what I'm asking. I'm asking, is there an equal parenting time agreement where the defendant will have the child 50% of the time?
Yes, but yes.
Okay. Is there public assistance involved in this case in any way through Medicaid, housing assistance?
No. No.
Okay, sir, is that your understanding as well? There's no public assistance?
I did not know that. I thought that at least I was paying insurance on top of that.
Okay, that didn't answer my question. I asked if there was public assistance involved that you are aware of.
What is public assistance?
Public assistance is food stamps, Medicaid, housing allowance, anything that comes from the government.
Oh, I mean, not for me.
Okay, that's what I'm asking you.
No, not for me. No, I don't have anything. No, sir. No.
Okay. And the plaintiff has stated she did not either. As a result, the court will grant your motion, sir, where you can recalculate support based upon an equal parenting time schedule. So you take your income, the plaintiff's income, put it into the support calculation in the formula, and you will come up with a support amount. You can reflect reflect that in an order for child support. And I don't know what it's going to do because I'm not aware of whatever your income is or anything of that nature. And then what you'll have to do is submit that to the front of the court for their approval. They will then check to see if there's any public assistance involved. And just to clarify if there is or not. So, and sir, and they have all the calculation and the formulas for calculating support and to do the orders as well.
Okay. Is there, all right, so I can't ask for joint custody in this one. I'd have to.
No, you asked for change in child support.
I really wanted to change to 0.
That works.
Well, but at the end of the day, sir, you asked me to get a better job, right? And I can't because I got the whole city to know me at this point in time. And it's been hard for me to make money. And
not going to get into that. What this is you did with regard to support, of course, grant your motion. You can do the support based upon equal parenting time, 182 and a half overnights. And then you would reflect that in the order center.
Okay, I see what you're saying. Yes, sir. I do understand you now. I'm sorry. I apologize, Your Honor. I apologize.
Okay.
I'm sorry.
Yep, submit that and if you submit it within 7 days, you can submit it under 7-day notice of entry. If you don't submit it within 7 days, you have to motion the matter back before the court in this case. So that's up to you on what you do, but you're going to have to do it right away then.
All right. I was going to ask Joni on the other hand, sir. I'm asking her, is there a way that we can remove arrearages so that way I can?
I'm not dealing with that today, sir. You only filed the motion as it related to support. If there's anything else
I thought that was part of it.
If there's, well, it's not with regard to calculation of support. You're going to have to talk to her, and if so, you can always enter a stipulated order, which would waive the arrearages if she's willing to do that. So, but that's not before the court today. So,
all right.
Okay. Thank you.
Yes,
you're
sir.
free to go. Have a good day.
Thank you, sir. You too. Have a good day.
Thank you.
Just plowing through the docket today. Oh, I'm so jealous. So hungry.
Please unmute. Calling case 2023-2875 Marshall Moore versus Jalen Williams. Today is Monday, July 22nd, 2024 at 10:48 a.m.
The court will note that both parties in this matter are appearing in pro per. The plaintiff has filed a motion to set aside referee recommendation in which she states, and I quote, "I respectfully feel that as though the referee did not take any of my complaints or worries into consideration," end quote. Anything else, Ms. Moore, as it relates to your objection?
Yes, sir. I would also like to ask really quick if it is possible for me to speak to you privately.
No, absolutely not. The court does not have ex parte communication with any one party.
Okay, understandable. Well, I would like to state that I had to call the police yesterday and file a complaint on Mr. Williams. He did not drop my daughter off on time per, the court papers.
Okay, ma'am, if that happened yesterday and he did not comply with the orders, you have a right to file a motion seeking to show cause why he shouldn't be held in contempt for not complying with the orders, but that's not before the court today. It's simply your motion to set aside the referee order.
Okay, so I would have to file a motion to
have him held in contempt for violating the court order. And that's separate from this because that's not what we're here for. And the court will tell you just because the referee did not rule in your favor is not evidence that the referee made a factual or legal error. The court cannot set aside the referee order unless they made a factual or legal error. And simply, as you stated, that you don't believe that your complaints or worries were taken into consideration is not a factual or legal error. So I need to know what that might be. And if so, then we can look at that.
I tried to explain to the referee that he had left my child at home by herself. She has called me crying. Like, I tried to make all these complaints to the referee. Like, I written the letters that I was told to and made my complaints, and I don't feel like.
Clarify, ma'am. When you write letters don't mean anything. That's not evidence. You have to bring in witnesses. You have to bring in evidence to court. If you wrote a letter, for instance, to the defendant, you could bring that in and submit it as an exhibit, and then it would be evidence. But simply writing, letters to nebulous entities isn't evidence. So you have to present it at the hearing. And in this case, the referee saying you didn't do that, and therefore that's why he dismissed your motion.
Okay, well, I would like to request an adjournment. That way I can seek legal counsel.
Well, I'm not going to adjourn this matter. I'm denying the motion. You have not submitted that. We're not going to let it drag on. If you have a basis to proceed on something else, you can get an attorney, you can file a motion. But again, this is the time and place set for you to establish your case, and you haven't done so. So I'm denying your motion.
I just had to call the police on him yesterday.
I'm denying your motion, ma'am. You have to file a motion on that action. That's not before the court. You can't come to a hearing. You can't come to a hearing and then bring up all sorts of other things that aren't in your motion. Okay?
That's what the police.
The other side, in this case, the defendant, has a due process right to know why he's coming to court. And you can't come to court and say, okay, I want to address support. And then when you come to court, I want to address parenting time and custody and all sorts of other things. You can't do that. You've got to have a proper motion, and then the court can address it. So I'm denying the motion at this time. You don't need to do anything, sir. You're free to go. Have a good day.
Thank you.
Wow, Judge is super cranky today. Somebody shit in his cereal. Also, hi, Jody. We love you and Les. We're sending you good vibes. Oh, cleavage. Oh my God, now there's cleavage from Pat.
Why in this? Yeah. Kind of for objective. Can't remember.
Stephen Richards?
Good morning, yes.
Okay. Let me check.
I think I have. Yeah, we've got it for the court approval.
Oh,
I don't know why.
Judge is just having a bad day. I get it,
Unless
Judge.
they
It's a
just file
Monday.
it because it says
Does you have to file?
Yes, if you do have an FOC approval,
Yep.
exempting case from FOC services, initially it was objected to. That should.
Okay.
Well,
Call the case.
2024, 139.
I don't think I've ever heard him be like that. Wow. Call the case. I don't know why that stands out so much to me. It's just so gruff for him. Just like very. Oh my. Call the case, Paisley. Case. Call the case. Call the
9-8 DM, Stephen Richards versus Monica Richards. Today is Monday, July 22nd, 2000. 24 at 10:54 a.m.
Matters before the court on the motion to opt out of friend of the court services. The court will note that we did have friend of the court approval in this matter signed on July 10, 2024, and the motion apparently was filed before that. The court will, based upon the approval of friend of the court will grant your motion to opt out of friend of the court services. I guess that will conclude the matter then. I do note that both of you have signed the both signed the motion to opt out. So with that, I'll ask you, Mr. Richards, is there anything else that you have?
No, sir, I don't.
Okay, Ms. Richards, anything else?
No, I'm good.
Okay. We will get that order signed and that will complete your case and you have a good afternoon.
So as far as we have another court date on September, I think 11th.
I'm not familiar with what you have on September 11th.
This case is still open, so they need to obtain front of the court approval on their judgment UCSO yet. And it was just opened on May 8th, so we're not going to be able to finalize this case until after November.
You still have to, if you have agreement on all of this stuff, you have to still submit the judgment of divorce, the Uniform Child Support Order, and the judgment information form. Those three documents you have to submit to the front of the court for their approval. And then in this particular matter, we also have to wait the time frame, and that's 180 days before we can get it completed.
Yeah, I just didn't know because we were opting out of the FOC if I still had to turn all that paperwork in is what I was
Yes, you
asking.
do, because the front of that, and I report to court as to whether it's appropriate. The court doesn't have access to the information the front of the court does as to whether approve it or not. So you have to have it approved by them regardless of whether you go through the services.
Okay.
Okay?
I'll still.
As we get close to the 180 days, we can schedule in the final hearing.
Okay.
Okay?
Sounds
Thank
good.
you. You're free to go. Have a good day.
Final count. I hope you guys enjoyed that. I did. It was sure eye-opening. I actually worry for the first guy that we listened to and that lady. A little concerned about that case, but let's hope that I'm wrong and it's going to be totally fine. That's what we can hope, right? Tomorrow is Tuesday. Get your tacos ready. That goes for everybody. Get some tacos ready. We're gonna have a good time. I'm excited. Send some positive vibes to everybody. Let's just send some positive vibes out into the universe tonight. I'm gonna go send some. You can send some. We all will send some. Seriously, I really appreciate each and every one of you. Thank you for being here. Remember that I love you. I'm proud of you, and I will see you in the next video. Bye.